So switching gears to parking lots, because this comes up, this is a much bigger area where a lot of injuries occur. We're going to kind of review designated parking lots, off-site, public transportation, what's ordinary and customary way of coming and going, direct routes, and can you be deviating in the parking lot? So let's just set this up first. This is an aerial view of a parking lot. It's actually R&R Insurance's front parking lot. And there's the main entrance, and the red arrows indicate where there's a raised median with grass. The yellow arrows, there's sidewalks, and the green arrows indicate areas where there's a sidewalk that kind of goes through one of the medians. You can see the hash marks there. So that's kind of the layout of the parking lot. So let's go to a hypothetical situation. We have a scenario. Employees A, B, and C arrive in the same car in a carpool, and they just carpool together. They come in the same car. They park where the blue star is. Each employee gets out, and they all take a slightly different route to the front door. And A, B, and C, they all fall where you see the little explosion symbol there, right? A falls in the middle of the parking lot. B falls in the sidewalk that crosses the median. And C decides to take a little bit of a shortcut and crosses over the grassy median. Is each one considered to be in the course and scope of employment? Well, A, yes. Let's say there's just a slippery, and this comes as a shock to some employers that if an employee falls out in the parking lot, it's a workers' comp claim, but yes, it is. So let's say they slipped on some ice, fell down. Yep, A is in the parking lot. That seems to be direct enough. It's on the premises, no question. B, I would say the same as A, falls within the parking lot, falls on the sidewalk that goes across the median. That's a natural way to go. C may not be. C may actually be considered deviating for that brief moment of time crossing over that median. And I refer to the case of it's Oscar Mayer Foods. And what happened there was a little bit different than just a raised grass median. There was a median, like a raised grass median, and in addition to that, there was a cable fence, a small cable fence. So there's like a 2x4 or something in the ground, or 4x4 in the ground, and there's cable that runs between the 4x4s. And this person was running late, decided they were going to cut over this, and was crossing over the cable fence, fell down, severely injured their wrist. And the court said, that's not an ordinary and usual way to go in across the parking lot. So they said, nope, that's not considered course and scope, and and therefore she did not get workers' comp benefits. So in this particular case, A, B, no question. C, maybe not, unless they always go over it and there's a worn path. If there's some evidence that they use that path all the time, crossing over a median, and the employer doesn't do anything, it may actually be considered course and scope. So a lot of you change, again, Mary said, you change one fact, you can change the outcome of a particular case. So we talk about off-premises designated parking. So you've got parking that's somewhere else. You're covered as an employee going to and from as long as you have a direct route and in the ordinary and usual way. Now, in this next scenario, I'm going to contrast that to public transportation. So we look at the same overhead, and